Oh.
Yeah. I mean, Jackie, I think this is like the third meeting of the day I've been early for.
Ooh. You got a track record going.
I guess being in the office maybe actually helps me.
It's been a long day. We've been meeting since 9 o'clock this morning, meeting after meeting after meeting.
Well, it's a good thing you saved the best for last.
Well, it's 5:30.
Oh, try again. Call the meeting to order. Perfect.
Okay.
All right. So first on the agenda is to do roll call. Sounded like Lindsay and Scott are unable. They're not here. Looks like Jay, Leanne, Kevin, and myself are all here. So sounds like that's a quorum.
And this is a workshop, so we're not conducting official business per se. Well, I mean, it's not unofficial business, but we're not taking action, and that allows us to meet virtually today.
No voting.
So do we need to still then like move to adopt the agenda and vote on that, or are we just not doing that?
I don't think so. I think it's just there as a formality.
Okay. Yeah, I mean, you can do things like that, like adopt an agenda for a workshop because you're not taking formal action, but you don't need to as well. But things like that is fine.
Well, then it looks like let's just jump down to new business then, which is fair housing ordinance discussion.
Okay. So at our last meeting, you might recall, I was informed, I think it was the last meeting, the days are just running together now. I had informed the board about a housing complaint that was administratively closed because we did not feel the allegations gave rise to a potential violation of the ordinance. So as a reminder, it was about lawful source of income. And it was regarding the rent to income calculations. And what I will do real quickly, just to bring everybody up to speed, is I met with landlords and the Realtors Association this morning to do a brief update of our fair housing ordinance and the concern that's leading to wanting to amend the ordinance. So I can pull that up and go over that real quickly. Let me go to share screen. Okay, Mary, I think you have to stop sharing your screen so that I can share mine.
Mm-hmm.
Okay, and let me see if that will work. Here it is. Okay, and so I know we have 2 new members on the board, so this is just a refresher for others, but you know, I'll go over this for the new members. So our human rights ordinance prohibits discrimination in 3 areas: employment, housing, public accommodations within the geographic boundaries of Alachua County. And the city of Gainesville has a similar human rights ordinance. So their ordinance is enforced in city limits. Ours is everywhere else outside of the city. It prohibits discrimination based on protected bases, and they're listed here. And for our newer members, please stop me if I'm going too fast. I'm just, you know, assuming this might not be anything new for folks, but we do have new members, so I want to be mindful of that. Article 3 of the ordinance covers housing, fair housing. And in 2019, the board voted to amend the ordinance to provide additional protections in housing discrimination. And they added 4 new protected categories, and they're listed here: citizenship status, lawful source of income, veteran or service member, and being a victim of dating, domestic violence, or stalking. Most of the others, I believe, are pretty straightforward. You know, if we go back and take a look at things like race, color, religion, disability, I think those are pretty straightforward in terms of understanding. And even with the new ones, it's pretty straightforward, discriminating against someone because they are a veteran or a service member, or because they were a victim of dating violence or domestic violence. And usually that involves a landlord trying to evict the victim because of the law enforcement presence. There's something happening there that's disruptive to the neighbors, and other people might be scared. So the victim gets re-victimized by being evicted by the landlord for the disturbance. So this is, saying focus on the accused, not the victim. And it would now be unlawful to want to evict someone who is a victim of domestic violence or stalking. So the other two areas that I spent a little time on this morning was citizenship status and lawful source of income, simply because it's not as readily clear, and we do have a concern regarding lawful source of income.
Excuse me, Jackie.
Mm-hmm.
I have a question.
Sure.
If someone is being evicted because of dating violence, and then how do they know and or get a complaint through, and what can happen for them to be having a place to live?
Well, the most common scenario I'm aware of involves having to call law enforcement when something is happening. You're being attacked.
Yes.
And you're calling law enforcement, and your neighbors might then become scared and upset because you have, someone who is violent living there, and might say to the landlord, we don't feel safe. This is going on, right next door. And the landlord is then approaching the victim to say, we have a concern, and all of this law enforcement presence, and your, significant other engaging in violent behavior. And so, wanting to move forward with evicting not just the offender, but the victim as well.
Right.
And now this victim, who, of course, is going through a traumatic experience, is now having to find housing, being evicted. So this provision is prohibiting the landlord from doing that.
Excellent. And the landlord does it anyway? What's the victim's report?
No, this is prohibiting that. So if the landlord does it, then it would be a violation of the ordinance.
It'd be a violation of the ordinance.
Right.
And how does it get reported as a violation of the ordinance? Does the victim come to us and
right.
report it?
Right.
Okay.
Or someone else might be aware of it and advise the victim to come to us. So it would be like any other complaint that we get that's a potential violation of the ordinance. It would be reported to us in some way. Then we would be meeting with the complaining party. And if we accept it and investigate, then of course, the report comes to this board to review.
And also just 99% of the time that in the criminal justice system, the victims also have victim advocates that know how to refer them over to the EOC as well.
Good.
Yeah, even the sexual assault and victims advocacy group in the county, they presented the same protections, just so that their victim advocates were aware of it and could make sure that they were connecting them with the right resources and everything. So this is something that's kind of well socialized in terms of the people providing those services.
Well, we are doing a great job making sure it's known. Thank you.
Okay. And we have the fair housing poster and brochures available in English and Spanish on the EO website. I tried to, open the brochures and go through them today, but apparently I was the only one seeing it, because I understand that the others in the meeting couldn't see it. So I'm not gonna try here, but essentially it spells out, this one here on the left is mainly for tenants, and it explains your rights in the different areas. This one here is more geared to landlords, and it's like a frequently asked questions. Can I evict someone for this? Can I, deny this kind of Q&A to help walk a landlord through the different protections. And this is a poster, housing providers are required to post at least a HUD poster. It is mandatory, but we encourage them to also post ours. And so it's available to be downloaded off our website. So citizenship status. This prohibits a landlord or agent of a landlord from requiring or requesting that any tenant or occupant, prospective tenant, prospective occupant or guest disclose or make any statement or representation regarding their citizenship status. So it's you can't require, request, or disclose. Part B, which I'll get to next, is about disclosure. So if you have that information as a landlord, you're not allowed to disclose to any person or entity information regarding the tenant or occupant's citizenship status for the purpose of harassing or intimidating, retaliating against someone for exercising his or her rights, like complaining about the poor conditions, or maybe harassment, and then get threatened with, well, I'm going to report you to ICE. And when I say ICE, everybody knows, that's immigration, because, okay. Again, stop me if I'm using terms, but yeah, don't want ICE coming to visit. So it's, again, if you're doing this just to intimidate the tenant or to retaliate, or also trying to kind of coerce them into leaving the premises, that's all prohibited under the ordinance with this provision. And there are a couple exceptions, and this provision does not prohibit a landlord or agent of the landlord from complying with any legal obligation under state or federal law, and from responding to a subpoena, warrant, or other order issued by the court. It also doesn't prohibit them from requesting information sufficient to do a financial and background check as they would with other applicants. It's basically just what you need to know to approve that, but not making decisions or taking action based on citizenship status. Okay. So lawful source of income. This, I leave this up for a while. It's pretty wordy, but basically this is saying any lawful or verifiable income paid directly to a tenant or a representative of the tenant will be included and considered a lawful source of income in housing. So as you are collecting, or the landlord is gathering information, documentation regarding your income sufficient to meet any minimum income requirements, all of this must be considered, including things like child support, social security, alimony, veterans benefits, and housing choice voucher program like Section 8 vouchers. And this pretty much is where most of the issues or concerns regarding the lawful source of income protection comes about, specifically regarding Section 8 vouchers.
Sorry, Jackie, can I interrupt again?
Sure.
Can we please go back to the last slide?
Mm-hmm.
The last sentence, renter or purchaser, does lawful source of income in our human rights rules apply to buying property also?
Well, it covers any real estate transaction.
Awesome, thank you.
So based on the complaints we have received since this ordinance, the amendments were adopted, they fall in two main categories. And the main one is the landlord refusing to accept Section 8 vouchers. And between April, when the ordinance was passed, and October, or I think we ran it through December actually, we were in public education mode, working with getting the word out when we got complaints. And, we actually were sent copies of flyers business cards. And so that said, we do not accept Section 8. I mean, really blatant and clear evidence, but we were not moving for enforcement at the time because it was still new. So we would pick up the phone and call the landlord and say, you can't do this. We would send them a copy of the ordinance. We would send them our brochures. So we spent a little bit of time, working on the public education aspect. And the housing authorities were doing the same, with their clients and, getting the word out. So this is mainly, what we focused on in terms of trying to educate the public and the landlords. You can't refuse to accept Section 8. You're not required to accept it if they don't meet your other qualification requirements, but you can't just automatically disqualify someone on the basis of having a Section 8 voucher. The other area we were receiving complaints on was on the rent-to-income requirements. It's very common in our area for landlords to require proof of income that's at least three times the rent in order to qualify to apply for a lease at that property. And if you can imagine, that creates a barrier, a hurdle for a lot of voucher holders. And we'll look at a couple of scenarios that will help to make the point. So here we have a property where the monthly rent is $1,000 a month. And we have someone with a voucher valued at $800. And then their responsibility towards the rent would be $200. And all of this is determined, calculated, put in writing by the housing authority. These are not made up numbers. The housing authority looks at every possible source of income that person has coming in. They look at family size, the number of children, the type of housing they will need, 2 bedrooms, 3 bedrooms, 4 bedrooms, and then they make a determination. Here is what you can afford. This is the most you can afford to pay. They look at market rate and the different rents and say, we will give you a voucher for X, and the difference you will pay out of pocket. And so the person with a voucher going out hunting for a place to rent has some parameters already based on what the housing authority has approved for them, right? So if the monthly rent at this property was, say, $3,000 and they have a voucher of $800, probably wouldn't work. But in this scenario, with the rent being $1,000 and they have a voucher for $800, this is more than likely. And the housing authority has determined, based on their income, they can afford to pay out of pocket $200 because they already make sure that what they put on that piece of paper to say the voucher holder will pay out of pocket max, the maximum they can pay out of pocket, is no more than 30% or 40% at the most of their income. So they have already done that analysis. So in this scenario, we have a landlord who requires 3 times rent to income ratio, and they just use a strict calculation. The rent is $1,000. You need to show us a monthly income of $3,000. So for a lot of voucher holders, this calculation, the requirement and the calculation serves to disqualify them, because chances are you wouldn't qualify for a voucher if you had, that amount of money coming in the first place. So this is what, and in the beginning, we weren't really understanding when folks would call us and say, the landlord isn't calculating, or the way the landlord is calculating my rent, I can't afford to stay there. One, we didn't really understand it because Section 8, and so was new for us, in 2019. And 2, it wasn't something the ordinance addressed. It never addressed, issues of calculation. It was a strict discrimination, yes or no, based on protected status. So if you look at the same scenario, but use a different calculation, this landlord still has a 3 times rent to income ratio, But the landlord is taking into consideration the money that's already guaranteed to him or her. The housing authority is going to pay me $800 a month. This is deposited directly into my account every month, 800. So the only thing the voucher holder is responsible for is 200. And so should I be asking the voucher holder to show me proof of income of $3,000 a month when they're only responsible for 200? You know, a market, I guess, calling the comparative a market tenant, meaning someone without a voucher, and they're looking at the full price. That person is being asked to show $3,000 because they're responsible for the full $1,000 in rent. The voucher holder, on the other hand, is only responsible for 200. So if the landlord calculates the income requirement based on what that person is required to pay, then you see it goes dramatically from $3,000 a month to $600. And the person is more likely to be able to qualify now for an apartment at this unit. So this is, in a nutshell, what we will be asking the board to consider amending the ordinance to allow or to require in any rent income requirement, for that to be, for voucher holders specifically, for that to be based on the voucher holder's portion that they're responsible for, not the full rent. And that is actually more apples to apples, because both parties, the one who is responsible for paying the full 1,000 and the one for the 200, the calculation is still based on what they pay out of pocket, even though the numbers are different. So we think this is a more fair approach. It certainly helps to remove a significant barrier to affordable housing, and gives a voucher holder a better chance of being able to find decent affordable housing than having to meet the same requirements as someone paying full out of pocket. So this was presented this morning. As I said, the Housing Authority, Gainesville Housing Authority has a regular chat and chew event with landlords, and they held one this morning and invited the Gainesville Alachua County Association of Realtors, and this was presented, and surprisingly, we didn't get, I was gonna say a lot, I would say we really didn't get any pushback. We had a question, and the question was the difference between the 3,000 and the 200. Yeah, the 3,000 and the 600 is so significant that, this person was saying the concern would be you approve it for someone who only has to show 600, and paying 200, and that person still has other living expenses and utility costs, and so we would be approving it, and the person has the potential to not be able to, keep up with the rent. So the Housing Authority responded and explained that part of what they provide includes an allowance for utilities. They know, for a 2-bedroom apartment or a 3-bedroom or a 4-bedroom, what I guess an average utility bill would look like, and if they approve a 2-bedroom for that person, and the utility is, say, I think the example they use, because they use a real life example for a 2-bedroom apartment, I think it was $149, I believe the number was. So they're saying this person's allowance would not just be 200, but would be 349, that we're looking for them, 349 in terms of no more than 30 to 40% of everything else they have coming in. And the Housing Authority, well, let me not say that. I don't know if they provide that 149. I think for those who have no income, they help to cover the utility bill at the unit. But I think if you have income, they include that as part of the calculations. But in other words, in responding to the concern raised by that person, the Housing Authority was saying utilities are already included because they know that's part of renting. Because the suggestion there was that we find, you know, more like a happy medium between the extremes of like the 200 versus a full rent. But then what happens to someone who has no income? And you might have someone who lost their job, they have no income, they have, you know, 2 or 3 kids, the housing authority is approving them with a full voucher for the value of a 3 or 4 bedroom place. If we were to consider something like that, what would happen to someone in that case? Because they would have no separate income to qualify, but they have a voucher that covers the rent. And according to what they were saying this morning, the housing authority also then provides other support for the family. So, you know, Courtney, you can chime in, but I don't think we heard anything this morning that would support, you know, doing a different type of calculation. And we couldn't find any other agency in Florida that's doing this, but there are some, I know, Seattle, Washington, DC, Cook County, Illinois, they all have in their lawful source of income a stipulation that this kind of calculation be done only on the voucher holder's responsibility. So just going based on some examples out there, you know, in the market, this is what they're using. And again, you know, picking a happy medium, what would that look like? It would just be an artificial number. So to me, this looks like, you know, a more straightforward, you're comparing what both parties have to pay out of pocket.
Yeah, trying to make the landlords account for something subjective like their living expenses puts a whole lot of gray space in that. I like the idea that this is more.
Yeah, I think this is more clear cut than, you know, who would pick what that number would look
like.
like.
Yeah, and who qualifies what living expenses they're including and everything.
Well, but this example, the 3 times ratio, that's a landlord created.
Right.
So the landlord, and I would feel comfortable if I saw it 3 times more than what they were owed or what they have to pay per month. So I guess I'm going to, you pose that question of, well, what if someone has 0 income and they're getting 100%? That seems like an easy one to me because that eliminates any risk from the landlord. They're getting 100% of the rent in the voucher. So, you know, that example obviously goes 3 times 0 is still 0, but it eliminates any concern a landlord would have. They're getting it, right?
About not paying.
And this is the intent of the whole program anyways. If you, if people have, you know, 3,000 or whatever, the whole rent and all of they're not on Section 8. If they have, I mean, like they don't get the voucher if they have all of that money. So it just feels like it's.
Well, that's what it was doing in effect, really. Ruling people out. It was actually used more as a barrier than anything else, because the person who is paying full market rate, there are no greater guarantees from that person who has to come up with that $1,000 a month for you than the person with the 200. Both are subject to either loss in income or other issues, and you would be going after someone to collect $1,000 a month, as opposed to, you know, someone who has to pay $100, $200, a smaller.
Or that person has $3,100 of expenses that month.
So the landlords, not in this morning's event, but in other events I've been with the housing authority, with their landlords who are currently in the program, they say they have a hard time understanding why there's so much resistance to it, other than the stigma, you know, because it's Section 8, there's that stigma with it. because he said, this is guaranteed money. He said, I have less headache with my Section 8 tenants because I know every month I'm getting that month. Others frequently call me, can you give me a couple of days? Can you give me 3 days? And I'm always counting down. And he said, with my Section 8 ones, I'm not. So the landlords in the program say it makes no sense to them. But when you talk with others, what you keep hearing back, it's all about stigma. Because there was one who said he had a, not in this morning's event again, he had a, I think, what did he say? He opened up his heart and rented to a Section 8 tenant, and this was maybe about 7-8 years ago. And he said, that person and her family destroyed my place. I'll never do that again. That's what you get for renting to Section 8. I'm like, oh my goodness. If that is not stigma where you're using one negative to say, you know, this is how I view anybody on housing assistance.
Well, and
so, you know,
we also got rid of the idea of resistance to passing the change in ordinance was also, well, now I'm forced to. So anyone shows a Section 8, then I have no choice. I was like, that's not what the law says either.
Right. Yeah. You still are allowed to, you know, apply.
They don't qualify for other legitimate ways, then you're fine.
Right. Now, interestingly enough, you know, we had this morning, and then I got a phone call this afternoon from one of our community activists who was very, very upset. And in fact, she wrote to both the city and county commission wanting immediate intervention. And it's about one of our larger properties. Courtney, it should be okay for me to mention the name of the property, right? Because the email went to the board.
Oh yeah, absolutely. And I'm sorry, I heard the chair come in and I was concerned because I thought I was here alone. Sorry for getting up.
Bivens Cove, which apparently was recently bought up by Collier Companies. And on their website actually says this property does not accept Section 8 anymore. I looked at it today, and they are telling them we are getting ready to, I guess, what do you call it? Like when you upgrade property?
Renovate.
Yeah. And I guess maybe trying to make it a little bit more high scale. So it's like Section 8 ones, and one includes a lady with a disability, is my understanding. They were all told, you know, goodbye, time to pack up and go. And so I looked at the website, the information that was sent to us, and it says there, really today, 2021 today, this property does not accept Section 8. So that's going to be an issue. It's in the city, so the city EO office, they're investigating. But the community advocate was just so outraged that she contacted both county and city commission about addressing this. So it still is a big problem, you know, and even with tenants there in good standing and paying when there's an opportunity to evict, it seems as if, you know, there is that attempt to still go ahead and evict. So I think obviously there still is a need for protections because affordable housing in Gainesville is a significant issue, and things like this, it, you know, doesn't help.
So is this going to be a similar process, I guess, where staff will make suggestions on what the wording is and the changes, and then the board will discuss? So
I took a stab at some language, and I was looking at it again today because it's very simple. You know, it was two prongs. First is that it's clear, written in the thing, that you cannot say we do not accept Section 8, even though that's, to me, that was clear in, you know, lawful source of income. We wanted to spell it out in the ordinance that, you know, you cannot say that or advertise that. And number two, that with regard to any rent to income calculations, that will be based on the voucher holders portion that they're responsible for. And I think the second part of that said, and we were limiting the multiplier to 3. I think that might be a problem, limiting the multiplier. So that was not addressed this morning in the presentation. It was just making the rent to income calculations based on the portion to pay. Because if you think about it and a landlord decides, okay, I'm going to get really ridiculous now and say I'm going to require 5 times or 10 times, that's going to affect the market person too. It's not right. Yeah. So it's not in the landlord's interest to come up with, you know, a ridiculously high number, because that number has to be evenly applied, right? So I think just business and market forces will require that number to stay reasonable. I wasn't sure if the county wanted to limit how far, you know, we wanted to go with limiting that multiplier. So I think we can still get where we want to go without that part. And in reading others, nobody else has limited it. So I'm having second thoughts about including that part in. It's whatever there is a multiplier, it will be, the calculations will be a little bit different for the parties.
I know you all, I was just going to throw out the suggestion of possibly, rather than trying to word a separate statute or exemption, just do a change in the definition portion of what income is. To change the definition of out of pocket, however you want to phrase that, so that it would fit within that ratio, whatever the landlord fits it as.
So yes, it will just basically say the calculation will be limited to this.
If you're doing, well, if you're doing calculation of, you know, rent to income, then just have it, if we do already, change it or have it included definition portion of what income means. And then in that definition portion, you can just say income means, you know,
like a new definition for lawful source of income. Like, right? Is that what you're saying? Like lawful source of income equals
or any rent to income ratio definition being income that is out of pocket, not including any sort of voucher or subsidy. Just a suggestion.
Yeah, I'm still drafting that. I will just mention too that another request we had was for allowing, I guess, a private party, if I'm wording this correctly, Courtney, allowing a private party to go to court if there's a disagreement with an interpretation of the ordinance. And I don't believe our county attorney is supporting that request. But like what happened in the case I told you about last month, where they were saying the ordinance as written prohibits the landlord from doing that. And we disagreed because we wrote the ordinance. We knew it didn't. That was never the intent. That's not the language. And so I know the attorney was frustrated and you know, kept trying to get us to see. And we said, we want to do this the right way. We agree with what you're saying on the concept. We just need to get it in the ordinance. It's not there now. So as we are talking about amending the ordinance, one of the things he also requested was to amend it to allow for, I guess, a private cause of action just on the surface. And Courtney, you can speak for Sylvia, but I think she says the county should retain the interpretation of its own ordinance, you know, that we don't want to write it in there to allow for a private cause of action on the interpretation of the ordinance.
Right. Well, so there was, that attorney was requesting kind of 2 changes. One, if he disagreed when Jackie makes a recommendation to the board to close a file and really not move forward with bringing it to the board, other than to bring it to the board and tell you that that's a recommendation, is to close it. He wanted to be able to challenge that in court, and that's not something we were comfortable with, and not something we felt like was the intent.
And if I can interrupt you just for a second, Courtney, sure. The ordinance also allows the board, when I come to them to say it's administratively closed, to ask questions, and the board can say, so it's already, that provision is in there, it's just residing in the board. He wants it, to be able to go outside, but it is, that.
Yeah, there is a mechanism,
yes,
for that the board can take a vote and direct say, staff to go back. And then he also wanted to be able to take to court when the board makes a determination that it doesn't meet the parameters of the ordinance. He wanted to be able to take that to court. And we felt like that's the whole reason why we have the Human Rights Board, is for you to listen to the cases, be fair and impartial, and make a determination. And that if you've met that threshold, then you've got a cause of action.
You just wanted an appeals procedure.
Yes.
Yeah. Okay.
So I think what we will be moving forward with is the amendment to the lawful source of income portion. Of course, it will be a public hearing. I invited him to participate this morning, and he did a great job helping to respond to the realtors, because he's very passionate about this, and he gave a real life example as to why these rent to income calculations can be such a barrier for folks, and to also show that we're being transparent. I wanted him in on the meeting and the discussion. So when we go to the board, I will make sure he's aware of that first meeting when we request the board's permission to advertise a public hearing on the amendment, and he can, make his argument to the board to see what they would like to do. And at this point, this is what, the end of April. I think maybe towards the end of May, Courtney, is that too early? Or certainly the first meeting in June, that we should be able to have everything ready to at least request a public hearing?
Yes, I would say the end of May.
The end of May, early June, we'll be moving forward.
Sounds good. Is that
how is a voucher typically valid for about 6 years?
That I don't know. I don't know how often.
I was just trying to think of like some language that might be more appealable, and I know it would be probably 1% of the cases, but getting into a situation where a landlord is concerned that they're calculating at 3 times the gap amount, like say 3 times the 200, but that voucher may be expiring before the lease term is up. And I think
so the landlord has to have 2 leases actually.
Okay.
One with the tenant and one with the housing authority.
Okay.
The housing authority is a partner. So if they sign a lease for a year, then
there's guarantee.
It doesn't expire mid-year.
Okay. So then they should be.
At the time of renewal, everything is reviewed again.
Okay.
So the landlord cannot enter into a private or separate agreement with the tenant. The housing authority has to be fully involved because they control everything, what the person pays out of pocket and what they pay.
Okay. So, I mean, they should have no.
Right. So at least on a yearly basis, when a lease is expiring, they should be having a conversation.
Yeah.
Okay.
And it really isn't a vote, or we can't, like take a vote or make any decisions, because remember, it's just a workshop.
Right. I was just going to ask if we had any public comments. And I don't see any. So should we adjourn?
Anything else anybody has to share? Any comments? Because that's it for me. Just wanted to bring you up to speed on where we are.
Yeah, no, appreciate it. That's good. Look forward to having the discussion on the change.
Okay.
All right. All right. Well, thank you, everyone.
Thank you.
Thank you.
Thank you.
Everyone have a good night.
You too.
Night.
Night.
Lindsay, I'm glad to see that you got to attend tonight.
Yes, yes. I'm sorry I wasn't at the last one. I look forward to joining the others.
Glad to see you. Nighty night.
Night.